All right, everyone, check in. For everybody check-ins checks in before I start, please. Right? About to change. Neither, you're good? Yep. Okay. All right, chapter 3. All right, so chapter 3, we're going to talk about interests and estates. This word you guys already know, right? Estates. What does estate mean? Very good. So, assets. Great. What about interests? So that's financial interest. That's separate, but we'll talk about that in a different chapter. But I'm glad you brought that up because when we get to financing, I'm going to explain also that this is a different type of interest. Interest is a charge for the use of somebody else's money in the financial question. And you'll be able to see this when the question pops up. You'll be able to see if it's financial or not. If it doesn't mention anything financial, then it's this interest we're talking about, right? So I need to know what this interest means. What do you guys think? To have an interest in somebody's property, what does that mean? Say it louder. The intention to buy? Okay. So you're talking about interest like have an interest in you being here, right? It's a little different. But this is good because I want everybody to answer things, right? Whether it's right or wrong, just answer because that's what's going to help you understand, right? Let's see what we got as far as answers here. encumbrance, prime road purpose, plural rights. Anybody else? We think interest. We talked about assets, so estate, assets. What about interest? YouTubers, you're always welcome to participate as well. All right, let me help you out. These are rights, claims, or benefits. Rights, claims, or benefits in someone else's real estate. All right, so I want you to write, when you finish writing rights, claims, or benefits, you're going to write in someone else's real estate. Because estates, we have ownership and we have right of possession. Interests, well, there's one missing, the right of possession. So you have only the right, claim, or benefit somebody else's property. Okay. So if we're talking about estates, interest in estates in land, when you see in land, that means we're talking about real property. Okay, so you're going to have, this means real property. And it's common sense because it says in land. This is a mouse. This is not land, right? So this will not be an interest in land or a claim or a right in land, right? So you see in land, we're talking about real property. So there's different types of estates. We have freehold and we have leasehold estates. Freehold and leasehold estates. Okay? Freehold, as the name says, is free of any holds. That means you own. So this is ownership. Okay? Leasehold, as the name says already, lease. So if there's a lease, there's a tenant. Okay? Now, what we're going to learn by the end of this section is that a freehold owner is also a tenant. Because tenancy simply means occupancy. Okay? Occupancy of possession. So every time you see tenant, it could be a freehold tenant or a leasehold tenant. The only reason why here I kept it as tenant renter, right, is for you to remember lease, rental. Lease, tenant. Okay? Freehold, ownership. Just as a quick reference. Okay? So let's talk about interest and estates in land. Let's start with interest. An interest in real estate is ownership of any combination of the bundle of rights. Right? And what are the bundle of rights we have? We have the right to possess, right to use, right to transfer, right to encumber, and the right to exclude. These are the rights we have. If you have all the rights, you have a freehold estate. If you have some of the rights, then you have less than freehold, so you are limited. It's a leasehold estate. So let's start with undivided interest. Now, an undivided interest is an owner's interest in a property in which two or more properties share ownership. The term undivided and indivisible signifies the owner's interest in a fractional part of the entire estate, not the physical portion of the real property itself. So what we're saying is, let's put this bubble right here. This means 100% ownership, and we have John 50% and Adam 50%, right? So we own 50-50. But what do we own? We own a house. And this house is a two-family. How do we divide 50-50? You're telling me that John owns the second floor, Adam owns the first. Well, who owns the attic or the basement or the garage? You see what I'm saying? So we have 100% ownership between both of us. We have 100% ownership of the property. It's indivisible or undivided interest. Why? Because we're not cutting this into sections. We're not doing that, right? We own our interest in 100% of the property. We own our interest in 100% of the property, not divided. So if the co-owners have an undivided equal interest, one owner may not lay claim on the northern half of the property on his or her exclusive use. Examples of interest include an owner who enjoys a complete bundle of rights, a tenant who temporarily enjoys the right to use and exclude, a lender who enjoys the right to encumber the property, right? And Natasha's like, that word again. Encumber, yes. Over the life of, so put cloud again, right, cloud. Over the life of a mortgage loan. A repairman who encumbers, again, the property when the owner fails to pay for services. The buyer who prevents an owner from selling the property to another party under the terms of the sales contract. A mining company which temporarily owns the right to extract minerals. You guys remember this already, right? We can sell the rights separately from the property subsurface. A local municipality which has a right to control an owner's use of the property, and the utility company which can claim access to the property in accordance with an easement. The interests differ according to, right, next page, how long a person may enjoy the interest, what portion of the land, air, subsurface the interest applies to, whether the interest is public or private, and whether the interest includes legal ownership of the property. So, let's go over interests in real estate. We have interests that give us possession or allow us possession of the property, and we have interests that have no possession or do not allow us possession of the property. Okay? Let's start with possession. If there is possession of the property, that interest is called an estate. Okay? Estate is ownership of something, right? With the right of possession in this case. Possession. If it's non-possession, then we have encumbrances, cloud, or we have public interest, so the government. Okay? They do not have the right. So if the government taxes you, does the government have the right to possess your property, to use your property, just because they tax? No. If a mortgage company encumbers, right, they put a lien against the property, I'll explain that in a second. If they encumber your property, does a mortgage company have the right to take the property from you? No, unless you stop paying, right? So that's what we're saying. These are non-possession interests. Possession interests or estates, we have the freehold and the leasehold. Freehold ownership, leasehold tenants, because they do have the right of possession. Okay? So interests are primarily distinguished whether they include possession. If the interest holder enjoys the right of possession, the party is considered to have an estate in land or right in land or an asset or ownership in land. Now, if a private interest holder does not have the right to possess, the interest is an encumbrance. Now, an encumbrance, cloud, an encumbrance enables a non-owning party to restrict the owner's bundle of rights. So why do I call it cloud? Very simple. Ready? Okay, great. So let's compare real quick. Actually, let me ask a question to everybody. Raise your hand if you guys are paying attention. Raise your hand if winter is your favorite time of the year. I don't see any there. Nothing here. What about summer? Okay. Spring? 3 people raise their hand regardless. All right, okay. Fall then. Autumn, anybody? Fall? Just one? Okay, Adrian. Just one. So here's the thing. Why is winter not the favorite amongst most people? Say louder. The weather. Why? It's cold. Inconvenient sometimes. Okay, what else? Say louder. Cloudy. Okay. It could be cloudy in the summer night or day. But yes, I know what you're saying. Why is it limited? That's where we're getting at. Why is it limited? Because of the snow. You cannot run, can you? Well, you can, but you might fall. Lula wrote, undesirable due to cold, less business, prevent you from going out, too much things to wear. Exactly, guys. So this is the thing. In the winter, right, and we have the clouds, it limits you because it's either raining or snowing, right? The cold, you're limited, you're restricted. Well, when we're talking about encumbrance, an encumbrance is a cloud on the title. Because if you have a tax lien, right? Or if you have mortgage, easements, which we'll talk about, or encroachments, these are examples of clouds or encumbrances. They limit what you can do with your property. If you have a mortgage, right? Let's call the mortgage winter, right? Mortgage is snowing, right? If you have a mortgage, can you sell your house without paying off the mortgage? Can you get out of your house without clearing the driveway from the snow? No. So the mortgage limits the title of your property. You understand? There's a tax lien. That means there's unpaid taxes. Can you sell the house without paying your taxes? Not unless the new owner agrees to pay the back taxes, which barely anybody does. So that's why it's called a cloud. Every time you see encumbrance, it's a cloud because it's a restriction on your rights. Which right in particular? Right? The right to transfer, for instance. But it could also be on the right to use if it's an easement or encroachment, as we'll talk about later. You guys good? Natasha, now you're satisfied that you know what a cloud means? I mean encumbrance? It's a limitation or a restriction on your property, yes. All right, public entities may own or lease real estate, in which case they enjoy an estate in land. However, government entities also have non-possessory interests in real estate, which act to control land use for public good within the entity's jurisdiction. The prime example of a public interest is the police power, or the right of a local or county government to zone. Another example of public interest is the right to acquire ownership through the power of eminent domain. We're going to talk about all these powers later on. So again, there's a lot of things on day one you guys are going to be confused about, right? And I can guarantee you that on day 20, you're still confused. But I'm going to do my best to clear things out as we go. You'll be confused for several reasons later on. One of them is not asking questions. The other one is not participating. 3, very important, probably the most important, is when you get out of here, of this class, this session, not using Quizlets. Quizlet is like these words coming back to you, right? So if you don't do that, I can guarantee you when we get to second week, third week, fourth week, get to the exam, be confused. The fourth one is obviously paying attention. Fifth one is paying attention. And the sixth one is paying attention. And the seventh one is testing yourselves, always. All right? Sebastian is like, yep. Well, even though Sebastian did pay attention in class, that happened after, but in class, paid attention. Outside of class, I don't know what happened. All right, let's see. Next we have an estate in land is an interest that includes the right of possession. What does the word inland mean? Sebastian says, yeah, me either. That's why I'm back. You're not the only one, Sebastian, but it's okay. Not the only one. Say it again. Estate and land is real property. Thank you, guys. Estate and land is real property. So if there's a real property, it's an interest that includes the right of possession. Estate and land, right? It's an interest in property that gives you the right of possession. Now, different estate and land on the next page. We have freehold and we have leasehold. I already cleared these out, right? If it's freehold, it's ownership. If it's leasehold, is tenants. Okay? Owner, tenant, because there's a lease. Owner or tenant, there's a lease, right? So freehold, free of any holds or any bars, right? Leasehold, you're limited to something. But you have an estate because you have possession. Possession of real property, when it's a temporary possession. Okay, so you own certain rights or interests in the property and allows you possession. So estate is still asset, it's still possession, everything is still the same, it's ownership. It's just that the tenant owns the rights to the land, right? Except one. They cannot transfer the land to somebody else. If it's residential tenants, they also cannot lease the land to somebody else or encumber the land. Okay? So again, right here, freehold estate. The duration of the owner's rights cannot be determined. The rights may endure for a lifetime, less than a lifetime, or for generations beyond the owner's lifetime. That's a freehold. A leasehold is distinguished by its own specific duration as represented by the lease term, so tenancy. Now look what it says at the bottom. It says both leasehold, right? Both leasehold estates are referred to as tenancies. The owner of freehold estate is a freehold tenant, and the renter, the owner, is freehold tenant, and the renter or lessee is the leasehold tenant. Because tenant means occupants. Or right of possession. Okay, so occupant or right of possession. So if you have a tenant, they occupy the property temporarily, right? That's what we used to. It's either you have a tenant or you are the owner, right? The tenant or the owner. This is just to help you because you might see freehold tenant. Tenant means occupancy. Who has the right to occupy it right now? If I give you a lease for you to occupy this space, can I occupy it? No, you are the leasehold tenant or occupant, right? If you're not here and I'm the only one here, then I'm the owner. I'm the freehold occupant. You see the difference? Okay, so tenancy means occupant or possession. Can I take over at the same time that you're here? No, you have a lease. I have to honor that lease. Okay, once it's over, it comes back to me. All right, so freehold estates, there's difference. Freehold estates. There's fee simple, there's life estate, there's conventional life estate, and legal title life estate. Under fee simple, all right, let's go to the next one. Under fee simple, this is the highest form of ownership interest. When you see fee simple, okay? The highest form, next page. Highest form of ownership interest. By the way, I'm giving you the heads up. Anything that I skip, like I can read the book for you, right? Which there's a lot of schools that do that. They just read the book, or I can explain it to you. So if I skip something, it's because I'm going straight to the point, and we're going to cover it better in the different chapter or a later section. That does not mean you don't have to read just because I skipped it. You have to still review it. Okay? So fee simple is the highest form of ownership. It includes a complete bundle of rights, and the tenancy is unlimited. So you're the unlimited occupant. You can stay there forever. Pass it along to your generations to come, right? With certain exceptions indicated below. The fee simple interest is also called fee interest or simply fee. The owner of the fee simple interest is called the fee tenant, right? And fee simple estates, like all estates, remain subject to government restrictions. And there's two forms of fee simple. There's absolute and the feasible. Okay? Fee simple, absolute. In the as the name says, it says itself, it's absolute. So you have absolute what? Powers or rights. Absolute powers or rights. It's yours. Yes, I wrote powers. You're gonna make me do this? Really? We can either waste time. Is it better this way? They're like, yeah, but I do read it out to you. I want you guys to all show me what you wrote and how does it look. Huh. Seriously. Natasha, you're going to come up here and write for me. I'm going to say it, you write it, and that's it. Hey, I need to work on my penmanship. What do you want me to do? Like I said, two things. I'm a lefty, and I'm writing on a tablet. That's at a 60-degree angle. So, hey, it's not... All right, the feasible. I'm going to write this one. All right. So you're going to write defeat. That's all you're going to write for now, defeat. Feasible defeat. So when you are defeated, right? What happens? You won or you lost? You lost, right? So in the fee simple absolute, you have full powers or absolute powers or rights, so nobody can defeat you, right? In the defeasible fee, or right, you can lose the property either by something that's determined or by a condition subsequent, right? That means there are conditions to your ownership. You're defeated by conditions. Okay? You're defeated by conditions. I'm going to explain that better in a second. You're defeated by the conditions of the contract, which we're going to go over in a second. All right? So, fee simple absolute, I already explained that. You have full rights. You can do whatever you want forever, right? And that's the most common. Let's go to the feasible real quick. So, fee simple defeasible. The defeasible fee is perpetual, provided that the usage conforms to the stated conditions. Okay? Provided that the usage conforms to the stated conditions. Essential characteristics are the property must be used for a certain purpose or under certain conditions, and if the use changes or if prohibited conditions are present, the estate reverts to the previous grantor of the estate. So, let's talk about conditions. Let's see, Joanna. I'm going to use you. Is that okay? Or as an example. So, Joanna, I'm going to sell the property to you, right? I'm going to sell my property to you as long as you use it for hospital purposes. There's a hospital. I'm going to sell to Joanna. And it's hers. Understand what I'm saying? It's hers 100%. So, Joanna, you can do whatever you want with the property except change the current use. If it's a hospital, it must stay as a hospital. Okay? So that's a condition that I put on the sale. Now, she's again the property owner. Joanna, you're responsible for taxes. You're responsible for insurance. You're responsible for maintenance. You can put a mortgage against it. You can do whatever you want. But the moment you decide, hospital, what for? Let's turn this into an office building, right? The moment you change to office building, the property reverts back to me. So I'm not the owner because I sold it to you, but the condition that I placed on this contract, on the sale, is what makes you lose or be defeated. It's a defeasible contract. You understand? You guys understand? So I sold to you as long as. So if you don't change the conditions of our contract, the property is yours. The moment you change the conditions of the contract, the property comes back to me. You guys got it? All right, anybody like this? Like this? Anybody? Oh, okay, good. You guys good so far? Great. So a life estate is the same thing. A life estate is the same thing as a fee, defeasible, right? Defeasible fee. The only difference is that the condition, instead of being hospital, the condition is somebody's life. So as long as somebody's alive, whoever we determined, let's say Monica, I'm going to kill you in a second. Is that okay? Just for the example purposes. All right. So Monica, I'm going to sell the property to you as long as you're alive. That's a condition. Notice that the terms are the same. I sell to you as long as you use it for hospital purposes, Joanna, right? And now for Monica, as long as she's alive. So when Monica dies, what happens to the contract? What happens to the property that I sold to Monica? Comes back to me. If I die first, it goes to my heirs. It never stays with Monica. Sorry, Monica. Right? So Monica's dead, doesn't go to her heirs, comes back to me, the property. I sold to her as long as she's alive. Now, Monica, you're going to live forever, right? That's what we expect, right? But when she dies, whether it's 10 years from now or 100 years from now, right? When she dies, either I get it or my heirs get it. Simple as that. So life estate is also a condition, but the condition is someone's life. The condition is someone's life. Now check it out. I can sell to Monica as long as Brian's alive. So I'm selling to her as long as the third party is alive. I can get more creative. Right? So Monica, your job is to keep Brian alive. Because when he dies, you lose the ownership. That's what it is. Okay? So this life estate allows you to own in limitation to the duration of the life of the owner or the named person. Or the named person. Okay, so either Monica, I sold it to her, or Brian, which is the named person, has no interest in the property. Brian's not the owner, has no interest in the property. I just named him as a security. Right? Now, who does this type of stuff, in case you guys are asking or wondering? Right. Not us, mere mortals. No, we don't do that. But the multi-millionaires and billionaires, they are trained by their accountants, for instance, and attorneys to do this kind of stuff. For instance, let's say, Natasha, I hope you don't mind. We're going to get married for a second. Is that okay? All right. So Natasha and I are going to get married for a second. And you have kids? You do? 1, 2, 3, 10? Only one? Boy, girl. Name? What is it? Isaiah? Okay, so here's the thing. I'm going to get married to you. And here's the thing. I'm going to be nice to her. Nice to Natasha. How am I going to be nice to Natasha? And tell me if this doesn't sound rich or wealthy. I'm going to be nice to Natasha and say, hey, Natasha, I'm going to give a house to your son. All right? Give it to him. But I'm going to give it to him as long as you're alive. The moment you die, I have no ties to Isaiah. Cold-blooded, just like that. I have no ties to him. Right? He's not my son. You're not my wife anymore because, unfortunately, you're no longer around. Why should he keep the property? You guys understand? So the condition was, as long as you're alive, your son has the property. Simple. Once you die, the property that your son has comes back to them. During your lifetime, and during Brian's lifetime, right? Isaiah, Monica, in my examples, they can enjoy the property. They can even sell the property or gift the property. So Monica, if you sell the property to Leslie, right? Leslie's the new owner as long as No, that's Joanna. You're not keeping up with this. I'm talking about Monica. I sold it to her as long as Brian was alive. All right, keep up. Keep up with the stories. By the way, guys, I do stories for everything because that's the way. In about a week, I'm going to talk about the story again. That's a way to keep you guys still within the same thought pattern. So, Monica, I sold to you as long as Brian was alive. You sold it to Leslie. So Leslie is now the owner as long as Brian's alive. Correct. Now Joanna sold the property to John, right? As long as you're not keeping up with the program. Joanna's the one with the hospital. Come on. So Joanna, I sold it to her as long as she uses for hospital purposes. She sells to John. Well, John is limited by the same conditions. What I'm trying to prove here is that it doesn't matter how many people you sell to, right? The condition stays unless I lift the condition. Because I was the one that created the condition. All right? Any deed restrictions or conditions, they stick with the property, not with the property owner. So if I sold to Joanna as long as she uses for hospital, and she sells it to John, and John sells to Lula, Lula sells to Pedro, and so on, all of them have the same restriction. As far as their lives, I sold to Monica as long as Brian was alive. She sold to Leslie. Leslie sells to Adriana. Adriana is going to sell to Zenaid. Guess what? They're all restricted by Brian's life. If during the transfer Brian dies, right? If during the transfer Brian dies, it's over. It comes back to me. You guys got it? If there's a condition, the condition will happen regardless of who the owner is, because I placed the original condition. You can only remove it if I remove it. You can only remove it if I remove it. Or if it's an unreasonable or illegal restriction. Like if it's something that's discriminatory. If I sold to Sebastian, but hey, Sebastian, the condition is never put any green people on that property. The moment green people touch that property, you lose the property because I hate green people. That's illegal. That's discrimination. Right? So that one will have no effect, Adriana. But if it's something that's legal, like the condition for hospital or somebody's life, then I have to lift that restriction or a court if I'm no longer alive or if my heirs don't exist either. If they own the land? Oh yeah, I have to sell it to you. I can only sell what I own. If I don't own, how can I sell to you? So you have to understand when you buy something, you're buying the land. If it has a building on it, great. If it doesn't have a building on it, you bought the land regardless. So yes, when I buy the land, I have the right to sell to you with restrictions if I want. As long as, again, those restrictions don't go against public policy, right? So they're not discriminatory or restrictions that would go against current zoning or municipal issues, right? Or regulations, then I can put that restriction as a seller only. Okay? Yes. I'll try to translate. Don't worry. Go ahead. I didn't say anything. Mm-hmm. Never gonna change. So if you sold the air rights to Simi, right? Then you sell the property to Natasha. Natasha owns the property, but Simi never lost her rights. This is the same thing we're trying to say. All the conditions stay the same unless Simi gives up the air rights, or unless you made an arrangement with Simi to dissolve the air rights before you transferred. So it stays as a condition. You own the property, but the air rights are not yours. But for hospital purposes, but as long as somebody's alive. So those go with the land owners. Yeah, stays as a condition. So air rights, water rights, subsurface rights, any rights that were sold, right, stay with a condition. In fact, me selling to you with a condition, like life or usage, I still keep a right or an interest in the property. It's called a reversionary right, right here. Reversionary right or interest. Think of me as the air right, right? Because I sold it to you. I sold it to you as long as, right? Whatever reason. I sold it to you as long as. If you break that reason, or if it ends, then it comes back to me. That means I have a claim, right? There's an encumbrance. There's an encumbrance because there's a limitation, a restriction right there. Claim, encumbrance, restriction. The property reverts back to me. That's the interest or claim that I have on your property. See, Simi has an air rights claim. I have the title claim. Revert back to me. All right? That's what it is. Adriana is asking, can you add restriction to a deed at any time? Well, the deed is only created for the transfer. So that means that the only time that you can add a restriction to the deed is at the time of sale. That's it. The deed cannot be reused or restructured. It's the time of sale, created a deed for that transaction only, and it stays. The thing is that it goes with future owners. It's attached to future owners. Okay. Now, remainder. There's a remainder interest, and remainder interest or remainderman. Okay. Every time you see remainderman is a third party. So what is a third party in this scenario? Let's say, so Liliana, you ask me, what if I'm dead, right? First of all, that will never happen. You guys are going to realize in all my examples, I never die. I'm the one that survives all of you, right? I always kill somebody else, just so you know. But let's assume, just you know, for entertainment purposes, that I'm dead, right? And let's assume I don't have any heirs, okay? Where does the property go to? Well, if I don't have any heirs, I could have appointed somebody else to receive the property. So I could have said, Leslie, right? I could have said that Leslie is to receive the property. So the sale is between me and you, Lydian, right? I sold it to you, right? But when let's say it's the hospital or you die or whatever, instead of coming back to me, I want it to go to Leslie. I have no heirs. I don't care about the property anymore. So it goes to Leslie. Well, Leslie is called a remainderman. You know why? Because she's not the first party. She's not the seller. She's not the buyer. She's a third party named. She remains of the contract. So she receives the property. So if I did not stipulate that it comes back to me, right, or my heirs, which is the way it usually goes, or my heirs, if I did not stipulate that, then most likely I stipulated a third party to receive the property. That's called a remainderman, and Leslie has a remainder interest. It's a future interest in the property that was not even hers. Okay? So yeah, I would die. It will come back to me, but because I'm dead, it becomes part of my estate. Okay? So if nobody claims it, then it will go to the state of New Jersey or state of New York or whatever the property is located. Where the property is located. Okay? Not where I live or where I died. Where the property is located by those laws. Unless I have a will. They sell it, they'll hold on to the money for, depending on the state, for up to a year. And if nobody claims it, they keep it. They keep the money. This is the reason I'm going to mention later on in a different chapter. This is the reason why having a will is so important. Then you determine who gets what versus the government determining who. Because if nobody claims it, I could have called the remainderman. Let's say it's a hospital purposes, right? When I sold to Joanna, I could have said that if Joanna changes it to office building, she loses it, and he goes to St. Peter's Hospital, let's say. St. Peter now gained the property. St. Peter is the remainderman, whoever I determine. I could do that in a will as well. A will could say that if I'm dead, at the time that it reverts back to me, right, this particular property would go to St. Peter's Hospital. So it's either on the deed or on the will, I can leave it to somebody else. It's just that if it's in the deed, this is called a remainderman. Okay, that's the only thing. There's no stupid questions. All right, so that's not a stupid question, but it is a stupid thing to do. So yes, it could go to a dog. It could go to a cat. Go to a parakeet. Whoever you want. These wealthy people do that, yes. Oh, it will happen. It happened in New York. Millions and millions of dollars went to a dog. And then somebody had to, be the guardian of the dog. And the guardian had restrictions. The guardian could not use the money for whatever. No. While the dog was alive, it was only for the dog. When the dog died, then it went somewhere else, or the remainder of the interest. So yes, if you want to leave everything to your dog, go ahead. Woof. People do that. That's what I'm saying. All right, reversion, I already explained that. It reverts back to me. That's reversionary interest. Now, in life estates, there's different type of life estates. Guys, if you don't have heirs, don't leave it to animals. I'll be the animal. I'll be the pet. Leave it to me. I'll do a lot better things with that money than a dog will. Just saying. All right, so think about that. You have no heirs. Sebastian, you got me, right? You're good? All right, cool. All right, conventional. Conventional or legal life estate, because we're under life estates, okay? So conventional or legal. Conventional, it's from seller to buyer. It could be ordinary or pour autre vie. Pour autre vie, someone else's life. Like Brian. No, that's French. But like Brian in my example, that would be a life estate conventional pour autre vie, based on somebody's life, right? Ordinary is to the buyer's life, okay? So ordinary is the buyer's life. It's me saying, I sell to you as long as you're alive. That's an ordinary, conventional life estate. Buyer's life. A legal life estate is for spouses. So I cannot put husband and wife anymore because there's spouse and spouse in most of the states nowadays. But if you're married, right? If you're married, you obtain the legal right to keep the property when your spouse dies. So if you're the surviving spouse, you have the legal right to keep it. So it's a life estate, legal. It could be Homestead, Darwin Courtesy, or Elective Share. Not Electric Share, okay? We're not killing anybody. But Elective Share. So I already covered the conventional, ordinary, and pour autre vie. Let's go straight to legal life estate. Homestead is your principal residence. Homestead is your principal residence. So certain states have different laws. Some allow what's called homestead, some allow what's called Darwin Courtesy, and then when you die, it's the elective share, and we'll talk about that in a second. Depending on the state laws. So homestead laws protect family members against losing their homes to general creditors attempting to collect debts. Homestead laws generally provide that all or portions of one's homestead are exempt from forced sale executed for the collection of debts. So if it's a house where I live and my wife lives, then when one of us dies, they cannot come and just take the property away to pay off the debt that I left behind, right? The surviving spouse owns it as if it was me. You understand? Or vice versa. So they cannot just come and take the property away. If it's a homestead, then it's protected by law. I'm sorry? Oh, they still have to pay. If they don't pay, then they're not exempt. They're not exempt. So debt, tax debt, self-financing debt, debts for home improvement, and mortgage are not exempt. So it must be the family home. If it's the family home, doesn't matter if you have a will or not, you're legally the survivor of the both of you. So automatically you obtain their 50 if it's a primary residence. And this is true whether you have a will or not, or if you have Darwin Courtesy, which is the next one. If it's the primary residence, it belongs to both. If it's an investment property, that's a different story. Then a will is important, or an elective share, as we'll talk about in a second. If it's the family home, does not matter. If it's a family home, it belongs to what? To both. Okay? Move forward. Next page, we have Darwin Courtesy. So this is an old ancient right. Old and ancient. I just both of those together. That's how old it is. So it's an ancient right in which the wife has a right. It's called dower when the husband dies. The husband has a right when the wife dies. It's called courtesy, right? So depending on the state that you're in, they might still allow dower and courtesy. So to address your question, Simi, if there's dower and courtesy, any property acquired under dower and courtesy is owned by the surviving spouse during the duration of their lifetime. Now, in those states that still allow it, in New Jersey, for instance, it was abolished back in the 80s. But if those states that still allow it, it doesn't matter who owns the property, and it doesn't matter if it's investment property or primary residence. Any and all property under dower and courtesy, remember this, any and all property belongs to both. Okay? So even if it was under my name only, and I acquired the property in the 70s or before, it was under my name only, and it was an investment property, it was not the primary residence, it belonged to both, no matter what. Okay? So therefore, to release the rights of dower and courtesy, both spouses needed to sign the documents. Again, even if only one of them owned the property. So dower and courtesy, everything, remember this, everything was 50-50. Everything, not just the primary residence. You can write it down like this. Dower and courtesy, everything was 50-50, not just the primary residence. Jersey, when they abolished dower and courtesy, they now have joint rights or tenancy by the entirety. The only property after dower and courtesy, the only property that belongs to both, no matter who owns it, is the family home. Everything else is investment properties. If it's under one person's name, it belongs to that one person. If it's under the other person's name, it belongs to that other person. With that being said, still consult an attorney before moving forward. And then we have the electric chair, right? What is the electric chair? Somebody's going to go to the state exam and look for electric chair on the answer. What is the elective? Sebastian says, yep. What is elective share? Let's say, before I show you the text, let's say, guys, that I died, right? Yes, second time today. It's crazy. Let's say that I died, and in my will, I left everything to my kids, but $0 to the wife. Okay? Elective share, this is on a state-by-state basis. Elective share is the spouse has the right to say, what do you mean he left me nothing? I put up with him all this time and I get zero? No. Your Honor, I'm entitled to X amount, right? And that's what the elective share is. Depending on the state that you're in, as an example, here in New Jersey, it's 1/3. You're entitled to a percentage of the deceased spouse's property, right? Except for the homestead where it's 50-50. But you're entitled to a percentage. So even if I put zero to the surviving spouse, you can come and say, no. I'm entitled to 1/3 of everything that Bruno owned. That's the elective, so I can elect to either want it or not. It's only available to a surviving spouse, right? It's only available to a surviving spouse, and if the surviving spouse does not file it, then it goes to the state again, and distributed by the laws of descent. So the state decides who gets what. All right? Elective share is the right of election. That's only for the surviving spouse, where they can claim something even if I put nothing. You guys got it? Right there. If they don't claim it, right there, if they don't claim it, the state passes according to the will or the state's laws of descent. If you don't have a will, the state determines how to distribute it, and if nobody claims them, nobody claims the right, the properties, then the state sells it, like I mentioned before, and holds on to the money until somebody claims within the year period or 2 years, depending on the state that you're in. After that, it belongs to the state. Again, that's why a will is so important, a last will and testament. Okay? Questions? Any questions you guys have? You guys at home? Questions? We're almost done. We're going to talk about leasehold estates. If we're talking about leasehold estates, who are we talking about? Tenants. Still louder? Renters. Tenant renters. Think about that. Tenant renters, because you could be an owner tenant, right? The freehold tenants. We talked about this. So if it's a leasehold estate, you are a renter tenant, right? What does the word tenant mean? Occupant. Very good. So let's go over these two. Estate, you guys already know, ownership and possession of something, right? What about estate for years? This is usually the most complicated one to understand. So I want you guys to tell me, if I have an estate for years, what kind of lease is this? Because this is a lease. If I have an estate for years, what kind of lease is this? Without reading, give me your best shot. If it's an estate for years, it's going to expire. Okay. Okay. Leslie says for multiple years. Sebastian says permanent, forever. Till you die. For years until you die. See me? Why? Specific. No, does it say for a limited period? You're actually right. You're just wrong on one part. It doesn't even have to be for years. What it has to be is for a definite period. I'm just collecting answers. Definite. I'll tell you right now. Okay. So estate for years is the most complicated one because it doesn't have to be for years. It could be for 1 week. It could be for 2 days. It could be for 10 years. The key feature is that if it's for a definite period of time where there's a check-in and a check-out. Okay? Check-in or check-out. So if you go to Airbnb and you spend the weekend there, you programmed a check-in date and you programmed a check-out date. Right? Were you there for years, Simi? In your resort or the Airbnb? Were there for years? No. But it's still considered an estate for years, only because it has a check-in and a check-out. If you tell me, Bruno, I have a 1-year lease. Well, if you have a 1-year lease, it means that it expires at the end of 1 year. That means your checkout date is at the end of 1 year. You guys understand? So estate for years, the most complicated one to understand. Estate for years is the one that lasts for a limited period of time. So it's there's a definite end date. There's a start date and an end date. The next one, the period to period, right? This one right here is the month to month. I mean, the month to month could be week to week. It could be year to year. The thing about this one is that it automatically renews. So while the estate for years ends, and then you have the option to renew, the month to month, or the week to week, or the year to year, if it has a period to period, never ends. Automatically renews as long as you pay your bill. As long as you get to the end of the month and you pay your bill, automatically renews. You got it? So there's 2 types of leases. Okay. For what? For the month to month? For the period to period? It could be a daily. It could be daily. No, not hours. Well, I don't know where you've been, but yeah, it could be hours too. They're laughing at home, yeah. Not what you guys are thinking, okay? This is 4 hours here. That's what we're saying. We blocked 4 hours. The period. Time. They rent a room. Oh, okay, boarding. Yes, same thing, same. Yeah. You can look at their faces though. They cannot see you, but you can. Their reactions are priceless to you guys say. All right, so yes, it could be a room. It does. We're not defining that it's the whole house. If it's a room, if it's commercial, if it's residential, industrial, we're not defining that. What we're defining is the periods of time. Are they a renewable period or it's a definite period? If it's a definite period, it's called estate for years. If it's a renewable period, it's called period to period. So again, if you're there for a couple hours, there's a check-in, check-out. If you're there for a couple days, there's a check-in, check-out. If you're there for a year, it's a check-in and check-out. That's a estate for years, right? If you're there without a termination date, right? Hey, as long as you pay me at the end of the month, you're good. Until we give each other notice, like this is done, right? Then it's a period to period. It's renewable. Okay? Good? At home? You're good? Great. Awesome. And then there's these two. At will and at sufferance. They both already tell you what it is. At will, it's my will that you're here. I allow you to stay here. Okay? At sufferance, I'm suffering because you're still here. So what do you think a state at sufferance is? What type of lease is this? Would you rent to anyone and suffer because they're there? No, but it's like the expired lease and you're still here. We did not renew. I already got somebody else to move in. So I'm suffering. Or you're not paying. If you're not paying, I'm suffering. I need you out. Okay? So at sufferance, it's a consequence. At sufferance is a consequence. We had the estate for years, and it was a 1-year lease. at the end of the 1 year, you're supposed to renew, but you're still here, right? I can either allow you to stay at will, indefinite, right? It becomes a month-to-month indefinitely. Or I can say you need to get out. So I'm suffering if you don't, right? Let's go back to the Airbnb. If you're in an Airbnb or hotel or whatever, resort, whatever, right? If you're there and there's a checkout date and a checkout time, out of courtesy, usually they call you and say, hey, just to let you know, your checkout time is at 11 o'clock. Please make your way to the lobby and check out, right? If it's 12 o'clock, you're still there, right? As a hotel manager, I have two options. Either allow you to stay a little bit longer or kick you out. If you don't leave, I'm suffering, right? If I allow you to stay, it's at will. You guys understand? The easiest way to remember is that at will is my will to allow you to stay here. At suffers, it's against my will, without my consent, so I need you out of here. All right? Just to recap, guys, we are done. Just to recap, right here, estate for years. Estate for years, again, it's a definite period of time with a beginning date, ending date. So check in, check out. Okay? On the next page, yes. All right. And then the next one, the estate from period to period, also called periodic tenancy, automatically renews for indefinite period of time. Okay, so we already covered this. It's all highlighted, so it's easy to go through. Tenancy or estate at will. I allow you to stay there, and there's no definite expiration date. I'm just at will. For as long as you pay, you're fine. Right? Very similar to the month-to-month. Okay? At will. And this one, sufferance, you're there without consent. Sufferance, you're there without consent. All right? So you violated the provisions of a lease and you have to be evicted. Right? Without consent. Any questions before we move on to chapter 4? We're going to do all chapters today, right? Is that what it is? It's a one-day class? All right. You guys have any questions? No? Questions, Simi? No? Guys at home, do you have any questions? Give me a thumbs up if you're good. Awesome. So, with that being said, if there's no questions, I'm going to give you guys, for those of you who don't have it, I'm going to give you guys my number. It's 908-418-8325. 908-418-8325. Guys, WhatsApp is my preferred method of communication. It's a lot easier for me to manage. I can have on my computer everywhere that I am. It's easier for me to answer versus text message or anything else. So if you guys have any questions, make sure you reach out to me on WhatsApp. If I don't answer right away, send me 2, 3, 4, 10. I have so many messages coming through. But if it's something that's important, send me as many messages as you can until I reply. All right? You also have the option, as I showed you before, I'm going to show you guys right now. You have the option to go to the school website. I'm going to show you on the portal, actually. And if you guys see, all right, if you guys see right here, at the bottom of the page, there's always the "We Are Here" thing, and you can click on it, put your info, and I will reply to you, or somebody, if it's something that's regarding the website, somebody in my team will reply to you. All right, so make sure you guys have all these methods of communication. Make sure you take advantage of the student portal. Make sure you watch the replay, test yourselves, go for the Quizlet, join the WhatsApp group. A lot of people ask questions in the WhatsApp group and other people answer, and it's great because we're helping. It's like a kind of like a group study without being a group study. You know why? Because group studies, I'm not there. The WhatsApp group, I can see the questions being asked and I can intervene at any point to help, right? I let you guys be for the most of it, but sometimes I do intervene just to give the correct answer, all right? So guys, make sure you guys take advantage of all that. With that being said, I'll see you tomorrow at 10. If anybody wants to join the evening class, it's at 5:30, all right? I'll see you guys. Thank you. No, not the same chapters.